Welcome everyone, and I'm just starting with a few introductions and introducing our agenda, and then we're going to get started. I'm Wendy Wagner. I'm a partner practicing out of our Gowling's Ottawa office. I've practiced in international trade for about 25 years, and I've never been busier. That's certainly the case. And so I have a broad practice in this area. I do both compliance and litigation, and it includes all aspects of customs and import. And I also advise on the implications of and interpretations of international trade agreements, something we're going to be discussing today. And also have a strong focus on national security within my practice and do work related to export controls and controlled goods and security clearances and sanctions as well. So I am frequently working with our procurement team, two members of which are on the panel today. So I will introduce them, Stephanie Pierce from our Ottawa office and Graham Regan also in Ottawa, two partners specializing in procurement law and leading our national practice in that area. So both Stephanie and Graham have deep experience in government procurement. They both advise both public and private sector clients on all aspects of the procurement lifecycle. That's from designing solicitations to navigating bid protests and litigation. They lead our firm clients through RFPs, tendering, and compliance with trade agreements and procurement policies. And their practices also span civil and administrative litigation, including tribunal proceedings and before the courts, including at the highest levels of the Supreme Court of Canada. And along with the rest of the team, their combined years of experience make them trusted advisors within procurement practices. So with that, I'm going to talk a little bit about what we want to cover today. So recent developments. There have certainly been a lot of recent developments in the world since January of 2025. So like every other webinar, topical webinar today, we are covering some of those developments. So Stephanie and Graham are going to talk about the recent appointment of a Secretary of Defense Procurement, our Defense Procurement Agency, and a new EU-Canada strategic partnership in the area. We've heard a lot in the past couple months about Buy Canadian and how that impacts procurement and procurement bans. And so they're going to be covering the new restrictions at the federal, provincial, and municipal levels and what it means to be a Canadian vendor or supplier in this context. They are going to speak about the role of trade agreement in procurement and one of the reasons why this session is so topical. And the national security exemption that allows our government and other governments flexibility to favor their own suppliers in this area. So I'm going to touch on some of the trade and security compliance considerations that often come up in the procurement context and how my group and Stephanie and Graham's groups work together on these issues. And then we're going to wrap up with some of the a summary of some of the opportunities and challenges in the midst of all this change. So with that, I'll let Graham and Stephanie get started.
Thanks so much, Wendy, for that awesome introduction. And thanks everyone for joining us this afternoon. We're so pleased to be here speaking with you. So as Wendy said, as with every topical webinar, we are going to spend a few minutes just going through some of the highlights from 2025. We've got a timeline up here on the screen for you, and some of these are things that we're going to talk about in a little bit more detail in the time that we have together, and some that I'm just going to hit quickly here. So first off, I think it's fair to say that the year started off with a fair degree of uncertainty with our government in transition and our new president south of the border. As we're approaching the last quarter of the year, though, I think we can fairly say that there have been a number of significant announcements that indicate change is underway in our Canadian defense sector. Looking at the first highlight in February, we started off the year beginning in February with the US government announcing some tariffs on Canadian and Mexican goods and Canada announcing counter-tariff measures. That is absolutely all I am going to say about the topic of tariffs during this conversation. This is something that Wendy and her team have spoken about and could speak and write about for hours. And so Wendy will touch on something to do with this a little bit more in the presentation, but really that's not our focus today. Certainly look Wendy up if you would like to talk any more about tariffs or learn any more about that. But we do have it on the slide because it is an important background to some of the other announcements, of course, that we've seen this year. In March of this year, in early March, there was a meeting of Canada's First Ministers, and Prime Minister Carney and the First Ministers issued a joint statement at that time about reducing barriers to internal trade and labor mobility across Canada. So in those remarks at that time, there was a talk about choosing Canada and making sure that all Canadians have access to Canada-made goods no matter where they are in the country, and tasking the Canadian Free Trade Agreement with being reviewed over the next 4 months. So over the next 4 months, that trade agreement, that internal trade agreement, was reviewed, with 53 exceptions being removed by June 30th, i.e. by Canada Day on July 1st. Moving forward to May, after the election, with the re-election of the Liberal government and Prime Minister Carney forming a minority government, he announced his cabinet and secretaries of state. And this is where we see the announcement about a new Secretary of State, which I will talk about in a little bit more detail. Moving on to July, we've got some Canada-EU discussions and the signature of the Security and Defence Partnership and Defence Investment Pledge between Canada and the EU. And then the reciprocal procurement policy, the interim policy on reciprocal procurement that Canada announced later on this summer. So as I said, we're going to talk about some of these in more detail, including this announcement about the Secretary of State for Defence Procurement. So in mid-May, when Prime Minister Carney announced his cabinet, we've got David McGuinty moving into the role of Minister of National Defence. And we've also got Stephen Fuhr, a former Air Force pilot, as Secretary of State for Defence Procurement. Now, this certainly isn't the first time that Canada has had a Secretary of State appointed, but it's the first time that this specific position has existed, specifically appointing a junior minister or a Secretary of State in the position of Defence Procurement. If you look at the appointment order that came with this, this role is actually assigned to assist the Minister of Public Works and Government Services. So that is where that position lives. It lives to help that minister carry out their responsibilities, rather than, for example, being assigned to the Department of National Defence. And then when we look at the announcements that came out following the appointment, this is where we get into the announcements around what is going to be the new Defence Procurement Agency. So this is an announcement that caught my attention and likely caught many of your attention in mid-April, actually, on the campaign trail when Mr. Carney was in Montreal at the time. He made an announcement that if re-elected, the Liberal Party would create a dedicated defence procurement agency. This idea of a dedicated defence procurement agency is certainly not new. It's something that was announced in 2019 under the Trudeau government, but any measures through 2019 onward to centralize defence procurement under a single government organization became interrupted by the COVID-19 pandemic in 2020, and we didn't see it come up again in the 2021 mandate letters. So many of you will know that centralizing defence procurement is not a novel idea. Many of Canada's allies have their own dedicated government department or agency to manage their defence procurement, and there's lots of lessons to be learned from those jurisdictions. The UK, Australia, France all have this dedicated agency managing defence procurements, and it's certainly something that's been talked about for years in terms of criticisms of our own existing structure and whether or not that centralization and that one agency is something that Canada would be looking at. Under the current structure, we've got the Defence Procurement Strategy Secretariat that lives within Public Services and Procurement Canada. And that secretariat is coordinating and implementing across several different departments. So you have the Department of National Defence and Canadian Coast Guard, who develop and define the operational requirements for the procurement. Then you have PSPC coming in with the procurement strategy and to lead the solicitation process. And then you've got Innovation, Science, and Economic Development, which is administering the Industrial and Technology Benefits Policy. So as of right now, we don't know if this new Defence Procurement Agency is going to modify the multi-departmental approach or not. We do know that in his first public remarks in early August, Secretary Fuhr was speaking to a group of defense industry leaders, and the emphasis of his take on his role in those remarks is really focusing on the accountability and being a single point of accountability for these defense procurements going forward. The available reporting in the media seems to suggest that in that role, he is going to be continuing to coordinate the multi-departmental approach. And we don't really have details yet on whether or how those departmental roles are going to be adjusted. One of the other things we know, however, is that Minister Fuhr focused on accelerating the defense procurement process and noted that the new defense industrial strategy is being developed that is really going to anchor this proposed defense procurement agency. We understand that the defense industrial strategy is underway, is going to be finalized in the coming months. And so we are certainly staying tuned to see what we are going to learn about the Defense Procurement Agency and hopefully what's going to be an evolution of our defense procurement environment from that strategy and the agency that is being developed. What we know from experience in some other jurisdictions is that one of the potential benefits of this centralization is centralizing the responsibility and enabling a nice, clear line of accountability. Secretary Fuhr's approach seems to have that goal front and center. What remains unclear is whether some of the other benefits of using a centralized agency are going to be met, including streamlining processes and reducing bureaucracy, getting some cost savings and efficiencies, and increasing flexibility and adaptability. So we're going to be carefully watching for further announcements to evaluate how the DPA and the industrial strategy will impact the defense purchases that Canada is embarking upon, particularly given the Prime Minister's announcements of increased spending and the recent pledge to reach our 5% of annual GDP by 2035 in alignment with our NATO allies. So I'm going to turn it over to Graham now, who's going to speak to some of the Canadian EU developments.
Thanks, Stephanie. So as Stephanie mentioned, on June 23rd, Canada and the EU announced the new EU-Canada Strategic Partnership of the Future, which is really aimed to strengthen existing relationships between Canada and the EU. And this announcement is going to serve as a first step in a series of comprehensive negotiations on various areas of cooperation. And those are going to include increasing trade flows and promoting economic security, fostering competitiveness and resiliency through this strengthened cooperation, achieving some kind of or deepening some kind of regulatory alignment, and hopefully shaping and promoting exchanges in education and innovation for technologies in the future. And coincident with the joint statement, Canada and the EU signed the Security and Defense Partnership, which focuses on building a framework for dialogue and cooperation in security and defense priorities. And obviously this was, in response to some of the pressures that we'd seen develop over the first course of 2025, as Stephanie mentioned. And in particular, the partnership has identified several areas of cooperation. Again, defense initiatives, capacity building for partners in security and defense, and also enhanced cooperation on security-related issues, cybersecurity, maritime security, and space security. In addition to those initiatives, in March of this year, the European Commission announced ReArm Europe Plan Readiness 2030. And this plan outlines the EU strategy to leverage defense investments, which includes a dedicated loan instrument for joint procurements. And that's related to the Security Action for Europe, or SAFE. And I'm going to talk about that in a minute. The plan is going to serve basically as a roadmap for breaking down national barriers and prioritizing EU-made weapons and pooling procurement and financial resources. And by entering into negotiations with the EU under the Security and Defense Partnership, Canada is positioning itself as an important partner in defense cooperation, in particular in creating a pathway for Canadian participation in procurement opportunities under the SAFE initiative. And the SAFE initiative, or Security Action for Europe, was announced in May of this year. And at a high level, it's a financial loan instrument under the ReArm Europe plan. There are two notable features of SAFE. The first is the European Preference Clause, which means that in order for EU member states to qualify for funding under SAFE, no more than 35% of the value of the weapon system being acquired can originate outside of the EU, the Ukraine, or a European Economic Area or a European Free Trade Association country. The second feature relates to joint procurements. And so a minimum of 2 participating countries will be required to undertake defense procurements jointly, or they're referred to as common procurements. And SAFE also provides that the EU can enter into bilateral or multilateral agreements with third-party countries under an existing security and defense partnership in order to expand on certain eligibility conditions. So what does SAFE mean for Canada? First, Canada stands to benefit from greater access to defense resources by joining common procurements with EU member states, which effectively creates like an international buying group arrangement. And second, when Canadian vendors are still eligible to participate in defense procurements issued under SAFE, in the absence of a bilateral or multilateral agreement, unfortunately, the geographic restrictions may limit the impact for Canadian defense contractors to participate. So hopefully there is some movement on those negotiations in terms of opening up further opportunities for Canada. So with that, I'm going to turn it back to Stephanie to talk about Buy Canada and procurement bans.
Thanks, Graham. And actually, before I get started talking about, we're going to spend about 5 minutes or so talking about Buy Canadian and procurement in Canada and some of the procurement bans that have either been implemented or been talked about federally and provincially. But before I do that, Wendy, did you want to speak about some of the other counter tariff measures?
Yeah, sure. I'll just give a quick update because not everyone may be aware of what's happened with Canadian counter tariffs. So, as most people will know, around March, early March of this year, in response to the US tariff measures, Canada did adopt 25% tariffs on US origin, a broad range of US origin goods. It was a pretty big list of about $30 million or $30 billion worth of product imported from the US and another about 29 billion in steel and aluminum products as well, and then later automobiles. So there's been a lot of sort of confusion in the media around this and exactly what happened on September 1st because the government announcements were a bit different than what actually transpired. But as of September 1st, Canada did lift almost all its counter tariffs on US products. So the only thing that now remains in place, which is very significant for some industries, is counter tariffs on basic steel and aluminum products, as well as passenger automobiles. So, and even there's for steel and aluminum, there's some pretty powerful remission availability of remission in those areas for further manufacturing in Canada and things like that. So, so all just to say that we don't have the counter tariffs in place that we had earlier in the year, and how that plays into this, which I've, Graham and Stephanie and I have been discussing, is that that's being replaced with other policies that that try to give a benefit to Canadian companies and encourage Canadian economic activity. And that's when we get into to the policies that Stephanie's going to speak about further.
Yeah, thanks, Wendy. So, coming up as a procurement lawyer in Canada, the thing that I've always been taught and kind of always lived by is that procurements have to be, or public procurements, when you've got a government entity making a purchase in Canada, it's got to be fair, open, and transparent. Everybody's got to have the opportunity to participate, and that's the level playing field. And so it's been a really, really interesting thing to watch these developments in 2025, to see different levels of government trying to find ways to say, actually, no, it's not going to be open to everybody. And we do want to try to make sure that we, in fact, are limiting access to our market specifically so that US suppliers cannot come to the table and cannot play anymore. And so, we've got a couple of different policies up here. Typically, of course, the provincial entities are not going to be doing defense procurement or purchasing things that might be as applicable in the defense industry. And so I'll focus on the federal policy that has come into place. And so the federal policy as of July 14th, it's an interim policy on reciprocal procurement. And the idea of the policy is that basically we want to ensure, or the government wants to ensure, that Canadian suppliers or suppliers from a country that have a reciprocal trade agreement are on equal footing. And that if you are not supplying from a country that has a reciprocal trade agreement, then you can't have the same kind of access to the government procurement markets and to the government federal contracts. It's designed to protect Canadian businesses and workers from unfair trade practices and to promote fair reciprocal access to procurement opportunities. Importantly, this policy does not apply to defense procurements. And so what does that mean? How do we define defense procurements for the purposes of this interim policy on reciprocal procurement? Well, there's a very long appendix in the policy that will help you with that. But the essential test is 51% of the estimated value of the contract for what is defined as defense goods, defense services, or a combination of the two. The exemption is only going to apply if the procurement is being made by or on behalf of the Department of National Defense, the Canadian Coast Guard, or the RCMP when they are acting in a defense or security capacity. And so you've got to ask yourself a few things when you're looking at, is this policy going to apply to the opportunity that I'm interested in? And that is going to include what is being procured, what is being purchased. Is it a defense good for the purposes of the Appendix A of the policy? And is it by one of these? Is it by DND, the Coast Guard, or RCMP? Also, there are certain goods that are being procured by those departments, which are non-defense goods. So those are also listed in the appendix, and you can double check. But for example, railway equipment and some vehicular components may be purchased by DND, but for the purposes of that procurement may not fall into the definition of a defense good. And so, there is going to be some important interpretation that goes along as this policy is getting rolled out and applied. When we're looking at defense services and exempting defense service contracts from the policy, examples include maintenance and repair of equipment, training of personnel, research and development, and things like that. So the takeaways are this new policy is going to apply to all new non-defense federal procurements that are over $10,000. Canadian suppliers remain eligible for all of these opportunities, and suppliers from countries with trade agreements with Canada that include government procurement provisions, applicable trading partners will also be eligible, but only to the extent allowed by that agreement. Wendy, did you have something you wanted to add there? Okay.
Oh, sorry. I was on mute there. I can't believe we still do that after how many years of daily webinars? Anyways, we do. Yeah, the only thing I wanted to add, Stephanie, is that it's interesting as Canada looks at some of these policies because way back when the WTO AGP was put in place and we started to have international trade rules and agreements that governed procurement, it's like Canada took the approach that we're going to use that as kind of a lowest common denominator or a highest common denominator, however that works. And in any event, we're going to apply our very open procurement policies to the entire world, regardless of whether they benefit from that trade agreement or not. And I guess in a sense that's very good from a procuring perspective because you're getting access to an entire world of potential suppliers, right? So maybe that was the view. But I think now the government seems more willing to look at the flexibilities within those trade agreements and who are actually members of those trade agreements that ought to benefit from those reciprocal obligations, and is there ability of restricting some of those benefits and the access to the Canadian market in a way that benefits Canadian suppliers or those suppliers in other countries with whom we have a very specific agreement. So, that flexibility, I think, has always been there. It's just the willingness of the government to look at it, especially when we know our trade partners are looking at that more and more and favoring their own suppliers, and that's the world that we're living in. So it's very interesting from a trade agreement perspective.
For sure. I think interesting is the word for 2025 so far, certainly. Okay, so then just very briefly on the other provinces, what you want to know about the provincial procurement restrictions is that Ontario and BC have both tried to come up with their own restriction policies, specifically targeting US suppliers, whereas the Manitoba one really does focus more on a Buy Canadian approach. And Graham's going to speak a little bit more about the procurement restriction policy for Ontario and how we define what a US supplier is, because it may well be relevant as we're looking at some of these other definitions and trying to navigate our way through the definitions of Buy Canadian and what a Canadian supplier is and then a US supplier. Okay, and on that, Graham, if you wanted to jump in.
Sure, and thanks, Stephanie. And I just add, one of the reasons that we're looking at, all of these other policies as we've seen, the level of activity and response by the government has been unprecedented in the course of a 8 months, 9-month period. And so we can anticipate that, there can be many more changes as we navigate the next couple of years. And to Wendy's point, I think the default openness has probably been replaced, at least presently, in Canada and how Canada is going to treat its trade agreement obligations. And we'll be looking at it more strictly. And I think what we're doing here is with this particular slide is trying to go through sort of the bare starting point in terms of understanding Canadian supplier. And obviously, one of the difficulties in instituting a procurement ban against a major trade partner is to decide how you're going to constitute Canadian supplier or non-Canadian supplier, as I'm going to get to in a minute, US supplier. And so, and this task is further complicated by geography, varying corporate structures and, independent commercial operations. So, we've highlighted Article 20 of the CFTA, which defines Canadian supplier as a supplier that has a place of business in Canada. And a place of business is defined as an establishment where a supplier conducts activities on a permanent basis that is clearly identified by name and accessible during normal business hours. Case laws looked at permanent establishment. It can be met by a Canadian supplier, at least in the traditional sense. If that's a Canadian incorporated corporation that's wholly owned by non-residents and has a situs branch where a place of business is established. So there are some guideposts in terms of what Canadian will be at a very basic level, but obviously the specific wording of any new policy measure and directives are important in terms of determining which suppliers are considered to be, quote, Canadian, and how this terminology will actually be applied to determine public procurement eligibility. So if we can go to the next slide. So as Stephanie mentioned, the interim policy on reciprocal procurement took effect in July. And that provides that a Canadian supplier has a place of business in Canada where it conducts activities on a permanent basis, with identified by name and accessible during normal business hours. So very similar to what we just saw. And it also includes applicable trading partners, and because of our existing trade agreements, that's a pretty open basket. Now, as Stephanie also mentioned, it excludes the application to defense procurements, where at least 51% of the value is for defense goods or services, which is fairly broadly defined. But recently, in early September, the federal government announced that by November 2025, they'll introduce new measures to make sure that Canadian suppliers and their products are prioritized in all federal spending. And this is the policy on prioritizing Canadian materials in federal procurement. And the idea is that it will require domestic and foreign suppliers contracting with the federal government to source key materials from Canadian companies. And this is going to be extended to defense and construction procurements exceeding a certain threshold, although initially it's really intended to cover steel and softwood lumber. But again, to what Wendy was saying, the idea is to introduce flexibility to allow the government to adjust the parameters to include additional domestic materials. And so that could be, we'll have to see what the policy wording is, but that could be an important tool in moving towards additional Canadian supplies, even in the defense context. And as Stephanie mentioned, we also just briefly note the Ontario restriction policy. The reason we do that is because it's by far the most restrictive, and also focuses on the US business. So, the Canadian policy is really focused on, as we've seen, as you can see, the Canadian supplier. The Ontario policy has done the opposite. And so it's a very restrictive policy in the sense that you not only does it has a quota of 250 full-time employees in Canada at the time of the applicable procurement. And it also applies to Canadian subsidiaries. So if you're a Canadian subsidiary whose parent is located in the United States and you have less than 250 full-time employees, this policy will apply. It's applied to all procurements. And so there are a handful of exceptions, but it's a very narrow policy. Now, we haven't seen that applied, as I say, outside of Ontario, but we are in early days. And so it's just to give a flavor of the kinds of policies that could potentially be applied elsewhere, or even at the federal level, potentially. So with that, I'm going to turn it back to Stephanie to talk about trade agreements.
Right. So we'll only spend a couple of minutes here on trade agreements, but we just wanted to touch on the point that, of course, Canada is party to a number of trade agreements, and these trade agreements have procurement obligations in them. They are not typically going to apply to defense procurements, and Graham's going to explain why in a moment. But for those procurements that are subject to the trade agreements, our bid dispute body is called the Canadian International Trade Tribunal. And that body has had some changes to its regulations this year to align itself with the new interim reciprocal procurement policy. And so we wanted to make sure that we highlighted that as part of this discussion. And so what are the changes that have come about? There's been a few. So the first change is making sure that the definition of a supplier for the purposes of a CITT bid dispute or complaint about a procurement process now aligns with specifically what is in the policy. And so again, we're looking at, are you from Canada? Are you a supplier from Canada? Or are you a supplier that's from a country or customs territory that is party to a trade agreement? So this is now spelled out in the schedule. It is something that would have to be determined by matter of course before the CITT as to whether or not you had standing there before. And of course, you need a trade agreement to get yourself in the door anyway, but it is now explicitly spelled out in the schedule as to who meets the definition of potential supplier. The new regulations also make it clear that a procurement process is over when the contract is awarded, and so they are not going to be looking at any kinds of disputes to deal with contract administration. It begins when the government institution decides on the requirement and ends at the time of contract award. And so that's, again, now clearly set out in the regulations. And then two new changes to the way that potential damages awards are being made at the CITT. For bid submission costs, that's now being capped at 2% of a complainant's bid price. And that is only going to be a case where somebody can successfully show the CITT that they were compliant when they put the bid in. And for compensation, for lost profit compensation, it's now going to be limited to 10% of your bid price. Or if it's unclear and it's more of a lost opportunity, that's going to be capped at 10% of bid price divided by the number of potential suppliers. And so, this should help to clarify things that have been known through the development of case law at the CITT and through its practice previously, but wanted to bring these changes to your attention. And so, Graham, if you wanted to cover off the national security exception.
Sure. So as Stephanie mentioned, I mean, this is the real reason that defense procurements are not subject to the CITT review, and the national security exemption, or NSE, effectively excludes a procurement from some of the obligations of the trade agreements where it's deemed necessary to do so in order to protect national security interests. And the NSE is only available federally, so it's not available at the provincial or municipal levels. And it's been used typically for national defense, but it's also been used for security intelligence, environmental security, and even human security. as we saw in the COVID times. So as you can see, the CITT regulations were amended in 2019 to establish the criteria for the proper invocation of the NSC and to provide clarification regarding the CITT's jurisdiction with respect to the NSC. And this developed out of challenges to the government's use of the NSC in certain cases. And so now the regulations provide that the NSC is properly invoked when an assistant deputy minister or an equivalent rank has signed a letter approving that the exception be invoked, and the letter is dated prior to the day on which the contract is awarded. So it doesn't even have to be done during the procurement process. So that's an important development. And then another section provides that the CITT shall order the dismissal of a complaint in respect of which an NSC has been properly invoked. Now, invoking the national security exemption does not necessarily remove all of the obligations of the trade agreements, but it does remove the CITT's jurisdiction to conduct an inquiry into the complaint, whether the complaint relates to the invocation of the NSC or other aspects of the procurement process. And importantly, the regulations do not require that the government provide a justification for invoking the NSC. And the reason that this is important is because the CITT is really the only avenue for federal procurement disputes to take place without going to court. And it is a fairly fast process, comparatively speaking, and also has a lot of remedies available to it. So by taking these steps through legislation, it's making it more difficult for suppliers in defense space to be able to challenge decisions related to those procurements. And now I'm going to turn it over to Wendy to talk about trade and security compliance.
Great. Thanks, Graham. Yeah, so I guess it's not directly relevant to everything that we've just been speaking about, but I think the point of intersection is that a lot of our clients are now starting to think about how do we need to change the structure of our business to benefit from some of these new procurement policies, and what's that going to mean from a compliance perspective, a transactional perspective, what kind of new obligations might we be getting into as we try and access the Canadian procurement market in this area. So, so there are obviously, unique compliance obligations when it comes to the defense sector, and a number of programs and regulations and laws that exist to govern those requirements. So one of the programs that's in place is the Controlled Goods Program. And it's administered by PSPC, the Controlled Goods Directorate. And basically, it's a domestic registration program. So if any Canadian company or Canadian individual, if they were, for example, a consultant operating on their own, does need to be registered with the Controlled Goods Directorate in order to possess, examine, or transfer what are defined to be controlled goods. And although it says controlled goods, it's not just goods, it's actually, it would be better named controlled items because it applies to technology and technical data as well. So the reason why we initiated this program back in 2001, I think it was the increasingly integrated defense sector between the US and Canada. And in particular, the fact that Canadian companies wanted to work on US and cross-border defense projects and to possess US origin ITAR goods within that context and technical data to be able to work on projects. So that was one of the sort of major instigating factors that led to the creation of the Controlled Goods Directorate. But it is a Canadian program in the sense that it's not just US origin ITAR goods that are subject to the requirements. It's actually a subset of military and defense goods that are also defined to be export controlled goods within Canada. So, so registration is required if a Canadian company or individual consultant is getting into the business of bidding on defense contracts and is going to be possessing any of those items, they're going to have to be registered with the Controlled Goods Directorate. And we put down some key resources there. The basis of the program, the constating legislation, is the Defense Production Act. Most of the requirements are set out in the controlled goods regulations. And then there's just a plethora of just different guidance documents that tell how the program is administered in practice. So moving on. So as I mentioned, just flip one back to export controls. The controlled goods program does have an intersect with also with our export controls division of Global Affairs Canada, because the controlled goods are actually a subset of a broader list of goods that may require an export permit when exported from Canada. So the Controlled Goods Directorate of PSBC does not itself address compliance requirements associated with the actual export of those goods. That's the the export controls division of GAC. So anytime you're exporting controlled or defense items or technology from Canada, there's very likely to be export control requirements that are layered on top of that controlled goods registration requirement. And again, just put down some key resources there. Next slide. So the other program that intersects with all of this is the contract security program, probably the one of the three that I've spoken about that's most directly relevant to procurement. So in the context of government procurements, the Canadian Industrial Security Directorate of PSPC mandates how recipients of government assets that have a security dimension to them need to treat those assets. And so that's in the context of government contracts. And those obligations will be on both prime contractors and will be flowed down by primes to their subprimes as well. And so that's another sort of pillar of this security apparatus that governs government contracts that have a defense or security application or assets involved in them. And we've put again some key resources there, but just consider it to be sort of one of those compliance pillars. So moving on. So how does this all come together, or what are some of the things that you have to think about if you're entering the market of providing products or services to relevant to defense? So when you're entering, if you want to enter contracts that involve a defense item, military or defense item, you're going to have to look at that issue of controlled goods registration and whether you need to be registered in order to possess those items and work on those contracts. And that would be whether it's a private sector contract or a contract with government in the context of procurement. And then in the context of procurement, those contracts, whether you're a prime or a subprime, as mentioned, they're going to have security requirements associated with them. So there's going to be a certain amount of preparation and work that needs to be done to ensure that you can comply with those requirements. The whole issue of security requirements also very frequently comes up in the context of transactions, which is one of the ways that people restructure to be able to look at bidding on contracts and participating in this market. So where does it come up? Readiness for due diligence processes. If you are a seller in this space and are looking to be acquired, you're going to be looking to see that you've dotted all the I's and crossed all the T's so that you're ready for that process. In the context of a transaction itself, the Controlled Goods Directorate does need to be notified in advance of any change in ownership. So that's something to be aware of when looking at transactions in this space. PSPC will need to give permission for assignments of contracts if the supplier that they've been dealing with is going to be purchased by another potential supplier. That's going to have to be addressed and dealt with. And then the whole issue of who holds export permits. What type of transaction is it? Export permits are not transferable. So if you have permits in place as a business and they allow you to export product for a 2-year period to a certain destination, you're going to have to look at if this is an asset purchase, how is the company who receives the assets going to be able to export from Canada and getting all those new export permits in place? If it's a share purchase transaction, that may be easier because the original company stays in place and they can continue to use those export permits. So those are just some of the considerations that will kind of be ancillary to this whole structuring in order to participate in this sector and participate in the government procurement opportunities that are there. I'll stop there.
A lot. So thanks, Wendy, for walking
Yeah.
us through all of that. Okay, so opportunities and challenges, just bringing this, wrapping up here, and I think we might have a couple of minutes for questions at the end. So I think those can be popped in the chat if folks have questions. But just speaking to some opportunities and challenges, on the procurement side, one of the things that we're really thinking about is what is this centralized decision making going to look like going forward, and how is it going to impact what has been a fairly slow defense procurement purchasing over the past decade or two is one of the things I think charitably the Canadian government has been said to be is a bit slow and inefficient. And so is there an opportunity now with the creation of the Secretary of State for Defense Procurement and the establishment of this Defense Procurement Agency? What kind of change are we going to get here? We've heard about the transparency and the accountability, which is certainly welcome. Is there going to be an opportunity as well to centralize some of this decision-making, streamline some processes, and improve some efficiencies? Are we going to see some centralization of the technical knowledge and the expertise, and actually, a full adjustment to the way that we've looked at some of these very significant projects in the past? Are we potentially looking at a different process from the usual RFI, RFP framework that we've seen so much over the years in the defense procurement space, and a pivot towards some of these more limited tendering opportunities and potentially sole source contracts? If that is where we're going, as we're looking at, how are we using the trade agreements? How are we using these policies and definitions of certain suppliers? I think one of the takeaways for the folks who are working in the industry is really making sure that you're in front of these announcements and these opportunities and being prepared to be responsive to the shifting definitions and policies, because it's uncertain what kind of competitive opportunities are going to come up, and if those opportunities are going to be open in the way that we've seen them previously, or if we are looking at kind of a new framework for the kinds of documents that we're seeing and opportunities that are going to be coming forward. So Graham, did you want to speak on the next one?
Sure. Yeah. So, the focus on Canadian content, I mean, it's pretty clear that the federal government currently wants more federal spending, including potentially defense spending, to go to domestic suppliers. And as we heard, unfortunately, the interim policy on reciprocal procurement is not really applicable in the defense context. And quite frankly, even outside of defense, given the fact that it includes opportunities for applicable trading partners, on paper, it's more or less the status quo, at least with respect to countries that have signed international trade agreements with Canada. So, there is a bit of a disconnect, at least currently, on that. Now, as I mentioned, this new policy on prioritizing Canadian materials, which is going to be released in November, may provide that opportunity to focus, at least to a limited extent, on domestic suppliers. And I think this is very similar to what Stephanie was saying with the centralized decision making. The idea here is to streamline the rules, to support domestic business, and really to facilitate better access to federal procurement. And, I think this is an immensely popular political move, and it builds on the tariff response protectionism that's really developed in recent months and arguably led to the election of the Liberal government. But the reality is it remains to be seen how this will play out. And I saw a question in the chat about how the different tariff regimes are going to apply to each other. And I think, that's one of the challenges here is how these policies will intersect with the trade agreement obligations. And really, how this will be dealt with is going to likely be a large administrative burden. And so I think, had one of these things happened as a development in federal procurement, it would be a monumental sea change. But to have several of them happening simultaneously really is going to test the limits of how effective the implementation actually is. And, I think it remains to be seen how, for example, the EU partnership development will work. That seems to be a bit at odds with the Canadian content requirements. So, there are a lot of balls in the air, and it will be interesting to see how this works out. But ultimately, I think if there is a strong priority to commit to a buy Canadian policy, this may end up having a bit of a higher cost, and it may take some time, but it also, in the long run, may actually increase Canada's independence in the defense space, and that would obviously have a lot of positive implications. Wendy, do you want to comment on the trade and tariff?
Yeah, sure. Yeah, I mean, I think just from a practical perspective, most people will be alive to this by now, but when entering any contracts, including government contracts, you have to look now at how tariffs can impact the contract price and whether it's actually viable given the tariff situation that we're in. As I mentioned at the beginning of the presentation, Canada did repeal a lot of our retaliatory tariffs, but there's still counter tariffs on steel and aluminum. I think what is less tangible is considering the fact that every project although we're encouraging Buy Canadian and all of that is a new thing. I mean, supply chains are still very, very global. So when you're bidding on contracts, it's not just a matter of will I have to pay tariffs on things I import into Canada in order to supply them? It's a matter of what will tariffs do to my costs within a global supply chain? And am I really fairly estimating what it's going to cost me to supply when, tariffs may be impacting me two, three, four rungs down the ladder where it's not that I'm importing into something into Canada and will be subject to tariffs, but it's that what I have bought in the United States, whether it's subject to tariff when entered into Canada or not, may be vastly more expensive because that US item contains foreign items on which tariffs had to be paid when it was imported into the US. So it's a very complex calculation, and I think we've only started to see the tip of the iceberg in terms of some of those inflationary costs because although it seems like years, we're only 8 months in to this new world and scenario. So a lot of companies were able to rely on inventory and on other arrangements. So we have not seen the inflationary impact that we will see within the next, I'm sure, a couple of months or the next quarter. So just to bear that in mind when you're structuring your contracts and your opportunities.
Great. Thanks, Wendy. I'm just looking at a couple of the questions that are in the chat, and I do see a popular question is whether or not we'll be making the slides and video available. And so, yes, absolutely. We'll be making sure that the recording is available for you as well as the slides. Another question that has come up is a question of what kinds of things national defense is going to be procuring. And is it going to be only heavy machinery, or can it also be textiles and items on a lower scale? And I think what we've seen all year, and I think it's likely to continue, is that we are seeing more and more announcements about the kinds of projects that are going to be underway under defense D&D and in the defense procurement space. Certainly, yes, lots of announcements around the bigger value contracts and the heavy machinery, but I think it was last week or the week before that we heard about the hiring blitz and the amount of resources that's going into making sure that we're recruiting and retaining Canadian Forces members and training them. And so that's where you're going to be looking at spending some of those GDP dollars towards the personnel and making sure that people are being hired and retained and trained. In terms of what we're talking about today and the reciprocal policy, Some of those other items, you know, the smaller contracts, if it's less than $10,000, it certainly wouldn't be subject to the policy. And if it is more than $10,000, but not on that specific list of a defense good, then it may well be a project that comes through that is under the policy and therefore does have certain kinds of parameters around it about who can bid on that project. And there would be then a preference for either a Canadian supplier or a supplier from one of our partner countries with whom we have a reciprocal trade agreement.
So Stephanie, I've got a question here, and I think kind of ties into what you were saying. It's basically asking how can these Buy Canada bans be permissible under the trade agreements? And I think, as I may have mentioned, the answer is really that the trade agreements are incorporated into the policy. So there isn't really a deviation. Now, I should mention that it's the interim policy, and the government expects to fully implement the policy by the spring of 26. And so what the full policy, although we don't really have much details, the intention is that the full policy will add supplier eligibility based on the origin of goods and services being offered. So again, I would anticipate that that's likely to follow along the current definitions of applicable trade partners. And so, would be consistent with Canada's trade agreement obligations. And again, it's also likely to have the exclusion for defense procurements based on the 51% threshold. So, at this stage, these policies aren't intended to exclude trade agreement partners. But that would be something that would be a departure, but they hasn't currently done that. So that's the answer to that question.
And if I can add to that,
Yeah.
Graham, like the one thing that a lot of people don't realize is that our procurement obligations under most trade agreements are very narrow. So, for example, under the WTO agreement on government procurement, it's mainly just federal procurement. It doesn't extend to provincial or municipal. So there's a huge area, and it's an opt-in agreement where you actually have to list the agencies or departments. You had to have committed to certain agencies and departments being subject to those obligations. It's not every agency and government department by default, with broad exceptions, in particular in the national security area. And one of our only trade agreements that has really robust procurement obligations is the CETA agreement with the EU. So I think it's interesting that the EU was sort of one of the first that we structured some of it, because we would be more constrained in excluding EU suppliers in comparison to suppliers from other locations. But there's a lot of flexibility there that just simply hasn't been used by the government because they weren't motivated to do it.
Yeah, absolutely. All right, well, I think we do have a survey that is available for folks to fill out. If you would take a minute, we'd really love to hear your feedback and to hear from you. Otherwise, I think we're just about at time. So I think we all just wanted to say thank you so much for joining us today.
Thanks, everyone.
Thank you.
Have a good afternoon.